Acquisitions and a commercial checklist for buyers. For potential investors and acquirers, carrying out commercial due diligence prior to an acquisition is an important exercise to be considered as part of the wider due diligence process. Conducting commercial due diligence will help potential buyers to understand the target company's commercial matters, such as the target's key commercial contracts, any data protection issues, and any intellectual property matters, as well as the associated risks concerning those matters. Being aware of the correct questions to raise during the commercial due diligence process will help to highlight and potentially either avoid or mitigate risks and complications, and ultimately ensure that an accurate valuation of the target company is obtained. So, with regard to commercial contracts, targets should look at business relations. Understanding the key business relationships that a target company has with its suppliers and customers will be a key aspect of the commercial due diligence process. To obtain such information, a review of the target company's key commercial contracts will need to be completed. A review will enable potential buyers to assess whether the existing contracts provide adequate protection to the target company. Consideration will need to be given to whether the contracts have been formed on a standard or bespoke basis, as the construction of the contracts will provide understanding as to the complexity, both from a legal and commercial perspective. It will also help to understand their value, to understand the extent of each party's contractual duties within those contracts, and also establish whether there are any onerous obligations. The review will also help to identify whether the contracts are a burden or actually a benefit to the target company, and highlight those contracts which are revenue generating and those which aren't profitable or potentially no longer fit for purpose. As such, distinguishing between these types of contracts will determine the relevance of each of them, and focus can then be attributed to those which are of a significant value to the business, and also identify those which need attention to either make them profitable or alternatively should be exited if possible. The review will also highlight whether the contracts actually allow an exit. It's important for buyers to ensure that they receive the benefit of the contracts acquired from the target company. Where there is a change in the ownership of the target company, consideration will need to be given to any change of control provisions. These may trigger certain consequences. They might allow a supplier or customer to terminate the contract following the sale of the target company, which could therefore put revenue for the buyer at significant risk. Alternatively, a change of control provision may simply require notification of a change in the ownership of the target to a supplier or customer. Further, the review should also identify the contractual length, but also particularly whether either party to a contract has the right to terminate without cause, meaning neither party is in breach, but a party can simply give notice to terminate. This would again put revenue at risk. Following an acquisition, the new owner may find that some of the terms contained within the acquired contracts may no longer be suitable for the business. For example, certain terms of contracts may no longer be suitable where a large company acquires a small company. It may therefore be necessary to try, if possible, to renegotiate those terms so that the new owner can operate the business in a manner which appropriately meets the business's needs. For example, when the contract was entered into originally, the target company may have subcontracted some of the services out to a third party because at the time it didn't have the capability to perform those services itself. If the acquiring business has an in-house team providing a range of support services, these may be more appropriate and could therefore potentially give rise to an additional income stream or a cost saving by way of consolidation or synergies. Turning to data protection and how personal data is processed, most businesses are likely to store and use personal information, which will subsequently give rise for a requirement for a business to comply with data protection obligations. During an acquisition, it's therefore important to assess whether those obligations are being adhered to. Potential buyers should ensure that a general audit is carried out into the types of personal data being collected by a target company and how that data is being used within the business. This exercise will establish if the target company is acting in compliance with its obligations under the GDPR, where applicable, which will include its data processing duties. The main types of personal data to be reviewed during an acquisition will include employee and customer personal data. In understanding a target company's collection of employee data, buyers will need to be informed of the flow of employee data within the business. This will identify the areas of the business, such as an outsourced function, which specifically process employee data, and therefore which certain obligations under the GDPR will apply. Similarly, buyers should also be informed of the extent to which customer personal data is collected by the target company. The data protection compliance of the company can be seen as a form of investment, as compliance with data protection laws avoids the cost and time in dealing with formal complaints or personal data breaches and subject access requests. To assist with understanding the target company's compliance with its data protection obligations, a review of its existing policies should be carried out to ensure that it's meeting its legal obligations, particularly those which require businesses to put in place data protection policies where appropriate. In addition, a review of the target company's existing data protection policies and procedures will determine the level of protection that's actually afforded to the personal data it processes. Moving on to intellectual property, or IP as we call it. The IP that's held within a business can often be a valuable asset of a target company. In effect, it's crown jewels. When assessing the IP-related matters during an acquisition, buyers will need to identify, where applicable, the types of IP held within the target company, if the IP has been registered, if there's a website and any domain names, and IP ownership. This issue will be of particular importance to a buyer, as they need to establish the owners of the IP, which often is not the target company itself, but the individual founders of the business. The due diligence process may reveal the need for IP assignments to be entered into between the relevant parties in order to effect the legal transfer of any IP rights, i.e. from a founder to the target company. In addition, a review of the target company's IP licenses should be carried out so that the buyer is aware of any restrictions that might apply to them in respect of the IP assets. In summary, the acquisition of a business can be something of a minefield. We're here to help guide you through the process to enable you to maximise opportunities whilst critically minimising risk. If you are a potential buyer or an investor seeking assistance with any of the matters that we've discussed, then please get in touch with one of the members of our commercial team today.